Hey, Paul here, and in this video, we're going to go over a very simple sample handwritten will that complies with Louisiana's validity requirements, and it would fit under a circumstance, for example, where a parent wants to leave their estate to their children. So, all right, so in these times where we're all following a stay-at-home order, the elderly, the seniors, they're not getting out, they're not getting anything done. Some of them are worried that they're going to get sick. Some of them are worried that they're going to get sick and they pass away. And so here's an example where a person can handwrite their own will, leaving their estate to their children. I'm going to show you a few different formats here, but let's take a look at it. All right, first thing I want to do is I want to look at the formality rules for a handwritten or olographic testament, particularly for the state of Louisiana. 26 states permit handwritten wills. Every state can be a little different on what their formality requirements are, but here's Louisiana's rule right here. An olographic or handwritten testament is one entirely written, dated, and signed in the handwriting of the testator. The testator is the person writing the will. Date may appear anywhere in the testament, but the testator must sign the testament at the end of the testament. Another sentence that says you really shouldn't write anything after you sign it. But it says here the olographic testament is subject to no other requirement as to form. That's it, entirely written, dated, and signed in your handwriting. Now, if you look at the other type of valid will in Louisiana, it's called the notarial testament. That's the more traditional, where it's typed up by lawyers typically, has what's called an attestation clause in it, which makes it valid. Also, it's required that the signatures be notarized by a notary and also witnessed by two people who are not family members. But the olographic testament, no notary, no witness requirement, just must be entirely written, dated, and signed in your handwriting. Okay, so let's take a look at an example where, for example, a parent may want to leave their estate to their 3 children equally, or however many children they have equally, and they want to name their executor. So here's an example. The date is written at the top. First sentence, there's a sentence like this in virtually every will where you're declaring it to be your will and you're revoking prior wills and codicils. Codicil is like an amendment. And here it is right here. I'll leave my estate to Peter Doe, Susan Doe, and Joseph Doe equally. So let's say John Doe, he has children. Maybe he's not married, either divorced, spouse may have passed away, and he just wants to leave what he has to his 3 children equally. It doesn't have to be children. He could leave it, but this is an example where he leaves it to certain people equally. And then he names his executor. I name Peter Doe, who happens to be one of the heirs, perhaps one of his children, as the executor. And we always suggest that you name an alternate executor. And in John's case, he named Susan as the alternate executor. And he put this provision here, which enables the executor to act under the more streamlined independent executor provisions and the important signature at the end of the document. Now, some people, when they leave it to their children, most want to leave it equally, but sometimes people want to leave it in percentages. Here's an example of that. Same first sentence, same date at the top. But let's say, for example, Peter has done very well and Peter doesn't need as much as maybe the others. Or maybe Peter is estranged somewhat from John and John doesn't want to leave Peter a full share. There could be any number of reasons where a parent or someone writing a will would want to leave things in percentages to their heirs. Important that the percentages add up to 100, same executor provision, same important signature at the end. So that's another form where here it's left equally, here it's left in percentages. All right, some people are concerned, hey, if I leave my estate to my children equally, what happens if one of my children dies before me? Well, it's not addressed in their will, but it is addressed in one of our Louisiana law provisions, which essentially says if you leave things to a child and that child dies before you or their legacy lapses, then accretion takes place in favor of their children, which in layman's terms means if you leave things to your children and one of them dies before you and they had children, then their share goes to their children. So if we look back at the example, let's say John prepared this will. 5 years later, Susan died. She had 2 children. 5 years after that, John dies. What would the 1/3 that would have gone to Susan would be divided equally between Susan's 2 children. Okay, few points to consider here is olographic wills such as this are only permitted in 26 states, and the rules can vary from state to state. even though you will have a last will and testament, if you do something like this, there's still going to be what we call in Louisiana succession, what we call in other states probate when you pass away. So there'll be that court and attorney involvement. If you would prefer that your heirs not have that court and attorney involvement, then perhaps you need to look at setting up a living trust, titling your assets in your trust. Assets in the trust don't go through that court and attorney involvement when you pass away. But the olographic testament, it is every bit as valid as the typed up, lawyer prepared, notarized and witnessed notarial testament. You can do it either way in Louisiana. This just makes this is a mechanism that makes it easier to get things done, and to get things done, quickly, in a matter of minutes, maybe even in a matter of seconds. Now, what I'm showing you here, it doesn't cover things like specific bequests. So let's say John wanted to leave his home specifically to Peter and then leave the rest of his estate a certain way. This doesn't address that. Some people just want some non-titled personal effects to go to certain people. So what some people do is they leave the will looking like this, and then they create what I'll call a non-binding, informal side letter, where it's just a letter. It's not part of the will. It's not a legal document, but here's one where Dad just said, look, I hope you'll carry out my wishes and make sure these items get distributed to these people. And then the 3 children who were named in the will, they'll honor Dad's request, and they'll distribute the gun collection, the clock, the baseball card collection, whatever, to the people that Dad had expressed. So that this keeps all of these people and these items out of Dad's formal probate proceeding when he dies. So he's keeping the estate legal document simple, but stating his non-binding requests in a side letter. All right, also, this is a scenario where those 3 heirs, they're going to receive their inheritance what's called outright, as opposed to in trust. Some people want to say that when I die, this child or these people's share will be held in a trust. They can't manage money. It needs to be managed by somebody else. It's doled out to them over time. This does not do that. Also, this does not appoint guardians. If John had minor children, I'm kind of making an assumption that John may be 60 or 70 years old. He doesn't have any minor children anymore. His children are adults. They can handle their share outright, and no guardians need to be named. Also, in this sample form, it doesn't provide for co-executors. Sometimes a parent wants all 3 of their children to be the co-executors, or they want 2 co-executors. This is really a simple form that provides for 1 executor and a backup. So there you have it, a real, kind of in its most simplest form, the simplest of all, olographic testament, single person leaving their estate to 3 adults equally, or 3 adults in percentages, naming their executor and their alternate executor. Anxious to hear your comments, whether you find something like this helpful. I can go a long way with this with other sample provisions and, quite frankly, other states' requirements. Also, real important that you smash the like button, also hit the red subscribe button and the notification bell, so the YouTube algorithms will keep my estate planning videos in front of you, so you can learn new stuff every day, or just about every day. Okay, we'll see.